The Consumer Guarantees Act governs the provision of goods and services by businesses to consumers. Under the CGA, both suppliers and manufacturers owe duties. Even though the consumers at first instance have strong rights under the CGA, consumers are to enforce the rights themselves. The CGA applies to any business providing consumer products or services, including tradespeople, professionals, online traders, importers, finance companies, and retailers. The CGA also applies to consumer products and services supplied by businesses, including if they're received as a gift, bought on credit, bought at auction, online, door-to-door, or other types of sales, or hired or leased. A consumer is defined as a person who acquires goods or services of a kind ordinarily acquired for personal, domestic, household use or consumption from a supplier. This includes obtaining by way of gift, purchase or exchange, and also means take on lease, hire or hire purchase, and it also includes companies. For guarantees to be given to consumers, goods must be of acceptable quality. This includes being fit for purchase, for which goods of that type are commonly supplied, have acceptable appearance and finish, free from minor defects, and safe and durable. It must also be fit for a particular purpose. This means if a consumer makes the purpose for why they are acquiring a product, then it must meet that purpose unless they are not relying on the supplier's skill or judgment, and it's not reasonable to rely on skill or judgment. Also, goods must comply with the description, and goods must comply with the sample or demonstration model. Consumers are also given the guarantees of repairs and spare parts, and that manufacturers will honour express guarantees. If one of the guarantees are not met, the customer can get a remedy. This can either be in the form of repair, replacement, or refund. If not remedied within a reasonable time, the consumer has rights to reject the goods and ask for a replacement or refund. If a good can't be fixed or its failure of substantial character, the consumer has the right to reject the good and ask for a replacement or refund. If there is only a business-to-business transaction between the parties, they will be able to contract out of the CGA, while both the parties agreeing that they have no rights under the CGA. If they provide products or services that are usually for personal or household use to other businesses, they may be able to contract out of the CGA. This means that if something goes wrong without the cover of CGA, the seller will not have to pay for repairs or give a refund or replacement. For business-to-business transactions, an agreement must be made if the CGA will not apply. This must be in writing. Both parties must be in trade, and terms must be fair and reasonable. If failure is not remedied by the supplier, either he neglects it or is not succeeding in doing it so within a certain time frame, the business has a potential risk of their consumers cancelling the contract for the supply of the service. Having a record of breaches of CGA would result in the loss of valuable customers, and the business would become less attractive to the buyers. Businesses not complying under CGA run a risk of their customers claiming damages for consequential loss. Take, for instance, a faulty electric microwave explodes and causes considerable damage to the customer's kitchen. The consumer is likely to recover the damages done to the kitchen, as well as for the inconvenience and distress because of the failure of the microwave, and is reasonably foreseeable. Reference to the case of Holdings Limited and Hosking, where due to a faulty electric blanket, the plaintiff was able to claim for the damages done to the house, as well as the convenience and distress suffered in due process under the Consumer Guarantees Act. The businesses also face the cost of extended warranty issuing for goods. It can be seen that the legality and compliances with CGA is very important to small and medium enterprises, otherwise they can face serious consequences. In summary, the consumer can recover damages for loss or damages to the consumer resulting from the failure, other than loss or damage through the reduction in the value of the good or service, which is reasonably foreseeable as liable to result from the failure.